You formed a Texas LLC, but is your operating agreement missing critical language? As someone that has drafted numerous operating agreements and, more important, has litigated over numerous provisions in operating agreements, I'm here to say if you just used a template operating agreement online, even if you use ChatGPT, and used it yourself and didn't necessarily enter the right prompts for including the right provisions, this is the video for you. Because in this video, I'm going to break down the top 3 things that I often see that are just crucial that are missing from operating agreements. Mistake number 1 is that there's no buy, sell, or exit provision or means to essentially terminate a member of an LLC. The rule should be that there are no transfer of membership interests without the unanimous consent of the other members, period. Okay. Well, what about when someone dies and their interests go into probate? What about if they get divorced and there's somehow like a community interest? What if they're disabled? The member's disabled and they can no longer participate in the company. What if they want to get out? What if they're bankrupt? What if, here's another one too, what if they steal from the company and start competing, poaching customers, poaching employees? What do you mean? You can't get rid of this member? That's literally absurd. So in all these instances, again, let's fall back to the default, which is there's no permissible transfers. Any transfers under any of those situations I just mentioned, they're all null and void. Now, you might be able to get a family law court or a probate court that will buy into this idea that some kind of transfer was permissible, whether through a will or whether through a community interest or something like that. You can use a belt and suspenders approach, which we often do, which will say in this instance, even though the transfer was void, if some court says it's not, this is how we value the interest in the company. Because now you're getting into a fight over what those membership interests are worth. And that's usually what the fight is about. If the company's making money and it's worth something, and someone has an interest in that company, they're going to fight over what it's actually worth. Same thing goes with that scenario when I said that there's a member of the company that starts competing with the company, starts stealing customers, this and that. It's really great to have a provision where you can terminate someone's membership interest for cause. But if you terminate, how are those interests valued? Are they valued at 0? Are they valued at 10% of what they'd normally be valued? It's really great to bake in that calculation up front to avoid tons and tons of disputes and litigation on the back end. Mistake number 2, that is no defined voting and decision-making powers. So here's the default rule: 1 person, 1 vote, unless you say otherwise. And your operating agreement is your chance to say otherwise. So we typically would say that you vote according to the percentage of membership interest that you have in the company. And then there is different levels at which a vote would be valid. So it could be majority, could be super majority. You have to define that. Super majority doesn't really have an actual definition. It could be 60%, could be 67%, it could be 80%, something like that, or unanimous consent. Now, if there's only 2 people in the company and you want to run it 50-50, or you require unanimous consent for every decision, great, awesome. That makes it easy, right? No, does not make it easy. You would need a deadlock provision. What if you decide to sell the company and 2 people can't agree, or they can't agree what to sell it for, and they just fight, and then you have to litigate over it. It can get nasty, it can get expensive, so I recommend putting in a deadlock provision. And back to the majority, super majority, typically you'd want a majority for like more day-to-day decisions, super majority for something a little more important, then unanimous consent for the most important of the important things like selling the company that I just mentioned. Another thing that you would put in here with voting and decision-making powers is whether the company's member-managed or manager-managed. That's the most important decision to make when you're forming the LLC. It's oftentimes the biggest mistake that someone makes when forming an LLC when they want to do it themselves. They don't think through the nuances of member managed, manager managed. By the time it gets to us, we're like, they really wanted to form a manager managed company, but they formed it as a member managed company. So now we got to go back. We have to amend the certificate of formation before we can move on to the operating agreement. And they end up spending more fixing everything than they would have spent if they just came to us from the very beginning to form the LLC. Mistake number 3 is there's no clear distribution and tax allocation provisions. You don't necessarily have to get distributions according to the amount of membership interest that you have. It's oftentimes very common that if someone puts up the money in the company, they want a return of their capital before there's this waterfall event and there's distributions to the other members of the company. I think most important from avoiding dispute perspective, I would say that the tax allocation provision is super important. I did a video on this, or at least it was in one of my other videos, about a minority member, someone that had got sweat equity in the limited liability company, had maybe 10, 20%. And the majority member was able to determine when distributions were made and in what amount. So here's what the majority member did. They got into a fight, the majority and the minority. So the majority said, I'm not going to distribute any profits. And this company was making really good money. It was a success story. But they're like, I'm not going to distribute any profits. We're just not going to take any at all. But because all profits are passed down to the partners from a tax perspective, that's called phantom income. And I've done a video on that as well. The majority and the minority partners were receiving K1s at the end of the year. So they were having to pay taxes on money that they didn't receive. So for the majority, no big deal. The majority had millions of dollars. They were able to pay the tax bill, no big deal. The minority partner, the one that was working for sweat equity, this was a really big deal to him and he couldn't afford to pay the taxes. So effectively, through this provision, the majority partner was able to squeeze out the minority until the minority just cried, uncle, take the membership interest. These are a liability to me. What a shame. If the operating agreement required there to be a tax advance, at least the amount of money to pay the taxes would have had to be distributed to the minority partner. And going back to the valuation of the company, if there was some sort of mechanism for when there's a dispute or one member wants out, this is what the company is going to be worth, some kind of formula to determine that amount, then the minority could have said, hey, keep giving me my tax allocations, distributions. In the meantime, I want out. This is what you need to buy me out for. And then they could have gotten a square fair deal. But because the minority just had the majority draft the operating agreement and then just pretty much signed it or didn't use an attorney or whatever the case was, simply put, the minority got screwed. So those are the 3 mistakes that I commonly see in operating agreements, which in Texas are called company agreements. Those are the 3 things, if you attempt to do any of this yourself, you should really drill down on the nuances and how these provisions can be custom tailored in your operating agreements. These are definitely the issues you should be discussing with your corporate attorney when you hire someone to prepare your operating agreement. If you do these things now, they can save you tons of money in the long run. It's like paying for an insurance policy now rather than dealing with the catastrophic event later.